Okay. Reading part 10, communication about legal sources. 10.1, advertising and related communications. Lawyer advertising is protected by the First Amendment, subject to narrowly tailored regulations by the government. Lawyers may advertise in any media. 10.1.1 Basic Rule: no false or misleading statements. A lawyer must not make false or misleading statement about themselves or their services. What's false or misleading? False or misleading includes important misrepresentations and omissions. Even a truthful statement is misleading if it would 1. Lead a reasonable person to reach an unfounded conclusion, 2. Reports the lawyer's achievements on behalf of clients and would lead a reasonable person to form an unjustified expectation of receiving the same results in a similar matter, or 3. Maintains an unsubstantiated comparison or claim of the lawyer's services or fees presented with such specificity as to lead a reasonable person to conclude that the comparison or claim can be substantiated. Depending on the circumstances, the inclusion of an appropriate disclaimer or other qualifying language can prevent an advertisement from being misleading to the public. California note: the California rule includes other specific examples of misleading communications: a communication that states or implies the lawyer is able to provide legal services in a language other than English unless 1. The lawyer can actually provide legal services in that language, or 2. The communication also states in the language of the communication the employment title of the person in the firm who speaks that language. A communication that states or implies no fee without recovery, unless the communication also expressly discloses whether or not the client will be liable for costs. So these examples, these hypos, right? No fee without recovery is one of the said disclaimers that can prevent advertisement from being misleading the public. I guess another one is about immigration services, and the paralegal speaks Spanish, not the lawyer. So, California statutory restrictions on advertising. The California Business and Professions Code specifically prohibits advertisements that contain any of the following. 1. A guarantee or warranty of the outcome of the case. To avoid a violation, a lawyer should always include a disclaimer that the advertisement is not a guarantee or warranty. 2. Words or symbols that suggest quick cash or a quick settlement. 3. An impersonation of the lawyer or client without disclosing that it is an impersonation. 4. A dramatization of an accident or other event without disclosing that it is a dramatization. A contingent fee offer that does not warn that a client who loses a case must still pay litigation costs if that is the arrangement. Although there is no specific ABA counterpart, these advertisements would likely also be considered misleading under the ABA rules. Okay, where'd they come from if they're not? Oh, these are all California. That was the California specific restrictions on communication. So 10.1.2, firm names, designations, and letterheads. Like any other communication about the lawyer or their services, a firm name, letterhead, or other designation, such as a website address, must not be false or misleading. For example, the name or designation is misleading if it implies a connection with a government agency or with a public or charitable legal services organization. For example, Sacramento Legal Aid Clinic states or implies that the lawyer's practice in a partnership or other organization, when that is not the case. Includes the name of a lawyer not associated with the firm or predecessor firm, but including the names of the deceased lawyers who are part of the firm is allowed. And 10.1.3, communication of specialties. A lawyer may communicate the fact that they do or do not practice in particular fields of law, and may also communicate that their practice specializes in, is limited to, or is concentrated in a particular field of law, as long as Such a statement is not false or misleading. However, a lawyer must not state or imply that they are certified as a specialist in a particular field of law unless the lawyer has in fact been certified as a specialist by an approved organization and the firm of the certifying organization is clearly identified in the communication. 10.1.4 must identify a lawyer or firm. Every communication about a lawyer or lawyer's services must identify the name and contact information of at least one lawyer or law firm responsible for its content. Solicitation. A solicitation is a targeted communication initiated by a lawyer that is directed to a specific person the lawyer knows or reasonably should know needs legal services in a particular matter and that directly or indirectly offers to provide legal services in that matter. 10.2.1 Live person-to-person contact generally prohibited. Subject to the exceptions below, a lawyer must not, by live person-to-person contact, solicit professional employment when a significant motive for the lawyer's doing so is the lawyer's pecuniary gain. That means monetary gain. Therefore, an offer to represent someone for free would not be prohibited by this rule. Live person-to-person contact means in-person, live telephone or other real-time visual or auditory person-in-person communications, for example, Skype or FaceTime, where the targeted person is subject to a direct personal encounter without the time for reflection. California difference, the California rule is the same with respect to in-person and live telephone contact, but more broadly prohibits real-time electronic contact. Thus, text messages and chat room messages might be prohibited in California even if there is no real-time video or audio component, but there is no definitive guidance on this point. Exception: certain targets are considered less vulnerable. Subject to the limitations of 10.2.3 below, a lawyer is generally not prohibited from initiating personal contact with any of the following people: another lawyer, 1, 2, a person who informed the lawyer, whom the lawyer has a familial, close personal, or professional relationship, including current and former clients, and 3rd, a person who routinely uses for business purposes, the type of legal services offered by the client. The California rule is similar but does not contain the exception for routine business users of legal services. In 10.2.2, written, recorded, or electronic communications are generally prohibited. Generally, a lawyer is not prohibited from sending truthful, non-deceptive communications, for example, via email, mail, or recorded telephone communications to persons known to face a specific legal problem. California difference. The California rule provides targeted communications must include the word advertisement or words of similar import on the outside envelope, if any, and at the beginning and end of the recording or electronic communication. However, the labeling requirement is not necessary if the target is another lawyer or a person with whom the lawyer has a close personal or prior professional relationship, or 2, is apparent from the context that the communication is an advertisement. When all solicitation is prohibited, a lawyer is prohibited from soliciting professional employment regardless of what methods was used or who the target is. If 1, the target has made known to the lawyer that they do not want to be solicited by the lawyer, or 2, the solicitation involves coercion, duress, or harassment. Section 10.2.4 Use of agents to solicit. Recall the lawyer is prohibited from using an agent to do something the lawyer is prohibited from doing. Thus, a lawyer must not use an engagement, sometimes called a runner or cap, to contact prospective clients in a matter that would violate the rules of professional conduct. All right, I have like essentially one more page. Um, 10.2.5, prepaid or group legal services plans. A lawyer is permitted to participate in a prepaid or group legal service plan that uses personal contacts to enroll memberships for the plan as long as the plan only controls persons who are not known to need legal services in a particular matter covered by the plan. Otherwise, this would be the lawyer must not participate in the plan that uses personal contacts if the lawyer owns or directs the organization that operates the plan. 10.3, paying for recommendations. A general rule, a lawyer must not give anything of value, it's just monetary, tangible items or services for another person's recommendation of the lawyer's services. However, the following exceptions apply. 10.3.1, tokens of appreciation. The lawyer is permitted to give a nominal gift or gratuity as a token of appreciation to the person who recommended the lawyer and the lawyer's firm, provided the gift or gratuity is not offered or given in consideration of an understanding that would that such a gift or gratuity would be forthcoming, or that referrals would be made or encouraged in the future. Reciprocal referral arrangements. 10.3.2, a lawyer is permitted to refer a client to another lawyer or a non-lawyer professional as part of a reciprocal referral arrangement with that person. For example, the lawyer sends clients who need medical help to a particular doctor, and the doctor sends patients who need legal help to a particular lawyer. Any such arrangement must not be exclusive, and the client must be informed of the existence and nature of the agreement. All right, the next section we're going to get to is 11, other duties to the profession and the public. But we're not going to do it right now. There's 9 more pages.